Good afternoon. Good afternoon. Three plans to prepare before retiring. That's going to be the subject for today. So, a few questions right off the bat. What do I need before retiring? You may be thinking, or when do I retire? What age is a good age, right? And commonly, when we think about retirement, we think about around age 65. All right. That's kind of like our average around here in the United States. Um, but a lot of these things you can do way before then, and you can do them afterwards. But I think a good rule of thumb, if you will, is to have these things in place before, again, before that age, that retirement age. Okay, and there are a lot of different schools of thought about retirement, about what it means, about what you should do afterward, about how to take care of yourself, and we can definitely explore all of that because it's very interesting to me and I see this not just in my professional experience, but also in my personal life too. So I have some thoughts on it. But today we're going to talk about specifically things that you will need before, again, before retiring. So let's say you're maybe about 60, right? Or maybe you're maybe 62 or, just in between that 60, 65 range. This is a good age to think about these things, but again, before. So it's always good to have these things in place even sooner than that. Okay. And we're going to talk about why here now. But before then, I just want to say why retirement? Because a lot of people, the baby boom generation, are retiring. They're reaching retirement age. They're getting older. They're having more um, kind of elder needs challenges. And not to generalize, but I've seen this a lot more, not just again in my practice, but in my personal life as well, where there are things that need to be addressed that maybe haven't been addressed before. Who's going to take care of who is a big one. And we're going to get into a little bit of that today, but not a lot. Again, follow along because these can be tough issues and we're going to deep dive into them along the way, along the journey. We're going to just kind of gloss over a few things. We're only going to talk about three plans to have in place today. But this stuff it matters in personal life. Who's going to take care of who? What happens when so and so, so and so? How are they going to live now? What are they going to do? Those kind of things can be tough issues to deal with. The more you see your elders get older, okay. And even if an accident happens, it could be a younger person. But again, I'm just seeing a lot more of this between that above 65 age, and that's why I said um, do it before 65, right? Because after that, things can accelerate and happen so quickly. And then we know just with the span of life and how much time is really moving by, things can get put off to the side, or maybe some things were done correctly, but other things were put off. The sooner you get it done, the better, okay? Because number one, you don't know if you'll have the time to do it later. Number two, you don't know if you'll be in the right state of mind to do it later. And that's a big one, all right? So let's just talk about these three broad plans to have in place before retirement. All right. The first one, and I also want to just say this quickly, okay? Like I've been saying a lot of stuff personally, because a lot of these things are happening personally in my own family, okay? And they happened to me 10 years ago, 11 years ago when I lost my father. A lot of these things were happening. All of these kind of decisions were being made. These issues were being brought up. But at that time, I was out of law school. I was freshly just graduated law school 2 months before my father passed. Okay. So I wasn't a licensed attorney yet. And I was also dealing with my own life issues and trying to study for the bar exam. Fun. Okay. So it was really hectic. So I had to see all this stuff going on, but really couldn't do much about it in the capacity that I can now. Okay. And so now I'm just seeing it happening to other family members. Some of whom had things in place, some of whom didn't finish all of them, but a lot of them are coming to me, and I'm just so blessed that I'm in a position now and in a capacity to do it now to be able to help them. Okay, with 10 years in here, so it's not something fresh and brand new or no experience like it was when I had just graduated, and I'm just kind of watching things go by. No, I can help them get by. All right, and that's what I want to do for you as well. And so a lot of the things we're talking about today, like I said, they're going on in my own family right now. Okay. And so I'm guiding them along and I'm also sharing the lessons with you. So the first kind of plan you want to have in place before retiring, you want to have powers of attorney in place. And I talk about this almost every week because this is something that I'm just so passionate about. You have to have these in place. medical and financial. Okay, a medical power of attorney is a document you name somebody to be able to specify what kind of treatment you like, what kind of care you would like, what you would not like, things that you don't want to go to. You can even have what's called a living will, like a pull the plug provision or not. You can do all that in a medical power of attorney. A financial power of attorney is same concept. You name somebody to be able to take care of your affairs, but for financial reasons. So somebody that can pay your bills, somebody that can sell your house, somebody that can exchange stocks with you, somebody that can basically do that kind of basic transactions. And again, some even more complex transactions like sell real estate. They are limited, so it's not like just unlimited and there's no check to the powers. In either one of those, that doesn't mean that you're the actual attorney. Only a licensed attorney can actually represent them, okay? And there are also some limits on creating estate plans, okay? And I don't want to get too far into the details of it, but just know that broadly speaking, a financial power of attorney is somebody that you name to take care of your finances, your real estate, your business. A medical power of attorney is somebody that you name to take care of your medical treatment, your prescriptions, your care, things of that nature. These documents are so important because these are people that you name to take care of your affairs while you are still alive, but you're not able. Either you're not in your right mind or you're just physically too tired to do it, to run to the bank, to do this, to do that, to even take yourself to go see a doctor, right? Um, just too tired to do it. So you can name somebody, you can do it. You can name someone to help you achieve those tasks, okay? And they're very important because they're the only documents that are in effect only at the time of death, okay? So they're very unique. They terminate at death. So it's not just some power you have forever, okay? But especially with financial power of attorney, you also hear it called durable, and it's durable because it outlasts a disability, okay? And that's why I say before retiring, because a lot of this stuff can set in after you retire, and I don't want you to do this, but often a lot of people retire and they just kind of sit around, or they get bored, don't have anything to do, and that's when the physical body can start to break down, and also the brain can start to break down, and that's what can cause a lot of onset of like Alzheimer's, dementia, and other things of that nature. And once the mental disabilities come in, you basically lose the mental ability to be able to affect these powers on your own. So before any of that stuff happens, have it in place already so that you are covered as far as, who can take you where, and what kind of treatment you want. You don't have to have the family around the hospital bed making those decisions for you, fighting over what nursing home you're going to go into and things of that nature. You already have it in those powers of attorney, okay? And again, I've seen some of these situations come up in my own family. What I can say that I am thankful for is that by and large, we've agreed on a lot of things as a family personally. So we haven't been back and forth fighting in court, but that has happened so often, okay, in my practice. And sometimes my clients are like, "Oh, I'm so sorry that this." I'm like, "Listen, it happens, and it happens more often than you realize. So you don't need to apologize to me, okay? I'm here to help you through it." So those are just the key benefits of powers of attorney. And again, very important that you have them before anything happens, because you are unable to execute those powers after disability sets in. And the dangerous part about that is then you have to go to probate court. You have to go to probate court to get a guardianship name for you, which is the equivalent of a medical power of attorney, or a conservator name for you, which is the equivalent of a financial power of attorney. Those take so much time. They cost money. And the supervision, there's just a lack of control on your part. Okay, it's all court supervised. The court can even name who's going to do what for you with their own attorneys that are on the roster, and it's a mess. Okay, that's something I don't enjoy doing. I have done in the past, and I have consulted on it, but it is not fun, and not even fun. Like it's not even effective. I'll put it that way. It's not effective. It can be very stressful, time consuming, costly. But again, the biggest key is the loss of control. that's what hurts me. I've been in court and I've seen people either in their own home or in a mental institution, and they're basically being talked over. There is another psychiatrist there to really say what their state of mind is, that they may have never even known the person, and the court is making a decision over that person. And it's very sad to watch, right? Because you're seeing a person, a live person there, just losing all ability to do anything for themselves. All right. And you see the government taking over for them. Now, it's supposed to be for a good cause, right? If they can't do it for themselves, but that's something you can do. And that's something you should do for yourself before any of that happens. Okay. Save yourself that time, that stress, that grief, all of it. Save yourself that and do it for you. Okay. So that's number one, is to have is to have your powers of attorney in place. Number two is property provisions. Okay. And when we talk about property, there are two types of property. Well, we can say there's actually more than that, right? Because with the digital age, wow, things are changing so fast, right? But traditionally, there are two types of properties: real property, which is real estate, land. Okay. And then personal property, which are things like cash, bank accounts, furniture, anything in the house, clothing, cars, right? Anything that's not land is personal property. But now, even with this digital age, you have digital property, so things online. Then intellectual property, right? Books and licenses and all that stuff. So that's pretty cool, right? Even the definition of property is expanding. But you can have provisions for all of this stuff before anything happens to it, right? That it gets lost or fought over somehow. So let's start with real property, okay? Houses, real estate, investment property, commercial buildings, commercial real estate, all of that. Any kind of land, even just vacant land, right? Undeveloped land, any of that you own. Have some kind of provision for who's going to get what, right? And talk about it among the family too, please. That's a big key. Talk about it among the family. Don't keep it a secret, because then somebody needs to figure it out. There are going to be fights breaking out, or disagreements. Talk about it openly and honestly, because why get it for somebody you want it to benefit from it, and you don't tell them about it, or you don't tell them how to use it and why you want them to benefit from it. Like, if you tell them, it'll just be that much more for them to grasp and understand. And if they don't want to, they can make the decision for themselves. Okay. But just be open. But when it comes to property provisions, and this is all kind of to avoid probate court, you can place the property in trust. You can place it in a business organization like an LLC, and the LLC will own it. Then there's another thing about, having a proper structure for who to take over an LLC. That's another story, but it's out there. Okay. This is a provision you can do. The business can own it. You can also have joint titles, like joint ownership titles. Those can be efficient, be helpful. They can get a little tricky if you ever want to undo them. So you just want to make sure that you do consult a professional to make sure that your plan is not only being executed the way you want to, but it can be undone, okay, without too much hassle if need be. Because, people change, plans change, okay? Be open to change always. So these are ways you can do that to avoid probate court. Okay, there's so much stuff. There's a lot. Don't be afraid of using the law to work for you. All right. A lot of people are just so scared. They're intimidated. They don't know. They feel bad about that, quote unquote ignorance. But, that's why we're here. Okay. Any good attorney will want to help you out through it and explain it to you in a way that's going to be beneficial to you, and that's going to give you a confidence in what you're doing. Okay. So, there are many different ways to do it. Just don't be afraid. Don't be afraid of it. When it comes to real property, again, and if you want to just kind of have that automatic transfer without going to probate court, these are a few ways. The trust will have its own provisions about how to give it to who. The business will have its own operating agreement and everything, a succession plan to figure it out. Joint titles, just depending on how you word them and how it's, titled. It'll have provisions for who get what and how the shares are divided up. So all of that can just be automatic. So that's the point. Automatic. So it's a straight transfer. And as opposed to going to probate court. So I'm going to tell a really quick story I just heard over the weekend of someone who, a daughter, I believe it wasn't my client, but a client of mine told me about it. A daughter who, I don't even know if they're out of probate court yet, but had to go to probate court after the father passed away recently. And the father, I don't know what he did for a living, but he owned 20 properties. So maybe he was a real estate investor. Maybe he was just, regular, 9 to 5 worker, but was an investor outside of that and had all these properties. Either way, there was no plan for how to distribute them. And when that happens, right, or that he's the only person on the deed and there's no other plan in place, there's no will, there's no trust, there's no joint property provision, it has to go to probate court, because probate court then has the authority to change ownership, right? Go through that process of probating the property, finding out who the heirs are, and then making the distributions that way. But with 20 properties, that means you have to go through each one of them and do it. And that is a headache. When I heard it, I was like, what? 20? It can be hard enough with just one. Trust me, right now, I have a case where just one, it took almost a year to get it resolved. Okay, but 20, whew. So that's a lot of time, a lot of money, okay? Because you got your court fees and you have creditors who might come after it. There may be other attorneys involved depending on who's fighting it. So it's a lot of hassle. If you can get it done like this and just have it be like a gear shift, like a clockwork, do that. All right. And those are a few ways that you can. So that's just real property. All right. Now let's talk about personal property. This is the easy one. I talk about this every week and I will probably forever because it's so easy. You can do it now. But too many people don't. They just kind of ignore it. Cash, bank accounts, retirement accounts, stock accounts, life insurance policies, basically anything where you can name a beneficiary, do it. Name a beneficiary to avoid probate court, okay? Because it'll be the automatic transfer again. These are also known as pay on death accounts or transfer on death accounts, because once you have your own ID and the death certificate, if you're the beneficiary, you go to whomever the institution is, the bank, or you present it to the life insurance company and they'll give you the money. All right, that's how it works. It just rolls out. That happened when my father passed away. I had to do that with other clients who unfortunately did not have beneficiaries listed. So we had to go to probate court. And what they could have had in a week, it took 6 months to do it. Okay. Don't delay your own benefits. And if you have these policies, know where they are, know what they are, who they're with, know who your beneficiaries are, and tell them. Let them know so they're not, digging around for it. They have no idea where to go, how to look. Let them know so that they can present properly, right? Because the companies will not just come and tell you. You have to have either you have to know, right, and have the death certificate, or you have to have a letter from the court. So don't hide this information, okay? Personal property, if you can name accounts, if you can name beneficiaries on the accounts, do that. It'll go like that. When it comes to cars, that can be a little bit trickier. In the state of Michigan, there is a process where if everything else is taken care of and there's only a car, and let's say it's only one car, you can basically do a title transfer, okay, without having to open up anything else. There's a specific probate court process for it, so it makes it a little bit easier to do. And it's not the big, long, drawn out process. There's a form you fill out, take it to the Secretary of State, and the title can be transferred. Okay, it's a simple process here in Michigan. Other states might have it, right? Or you check with your DMV. Usually that would be in place. If there's multiple cars, then probate court probably likely. All right. And with digital and intellectual property, that's an interesting one. We'll have to come back to that because I really originally didn't have it in my notes, but then I'm just going on and thinking like, that's new stuff too, right? But what I also do advise just with any kind of personal property, and you can also do, digital property with that. You can also make a list, just make a list and name out what it is and who you want to leave it to and attach that to a will. Okay, a lot of times that's sufficient and that will get probated. Some things, if they don't have a name on it, it will have to go to probate court. But if you make it very specific about what your intentions are, the court more than likely will have to honor it. Okay, you can also, again, put all this stuff into trust. Anything you can put intellectual property into trust, your digital property, there you go. You can put that into trust, okay? And the trust will have provisions about how to distribute it like that without going to court, all right? We're like this here. We want the instant wealth transfer, okay? And then finally, again, the estate plan. The estate plan is your traditional, well, it's all of the stuff we're talking about, but also the traditional, are you going to do a will or a trust? Okay. Trusts are very important to avoid probate court. Again, the hassles of probate court, it takes a long time. There's a minimum of about 6 months here in the state of Michigan. And it has to be open for at least 4 months to be able for creditors to come and say, hey, so-and-so owed us this much, we're going to claim it. Okay. So 4 months just for creditors to be open. And then again, there are court fees based on the inventory, which is the amount of the estate and how much it's worth. There can be inventory fees, um, and fights, family fights. That's the big one. You don't want that, and that is just so unnecessary. Okay, so unnecessary, but it happens. It's necessary to the point of a resolution has to be had this way. Sometimes they're just family members. They want to go to court, and that's it, and they will not do anything outside of the court. It has to be official that way. Okay, you using your time and money to do it, we got to do ours, right? So if it's worth it, you will do it. You'll get a resolution out of it, but it's just going to be a lot. It's going to be a lot, so just be ready for that. But trust can avoid probate court. It can avoid a lot of these family battles too, because the probate court does have jurisdiction to review a trust, to hear any kind of trust lawsuits that come up out of it, but it's a lot harder to challenge because a trust is so much more intricate, so much more detailed, so much more intentionally executed and done that it's hard to say, I think it's fake. Okay. Whereas like a will, we hear about like handwritten stuff all the time. Why really, if it's handwritten, how many times we just kind of doodle things anyway, right? And we can make that excuse. But if it's something that has been diligently prepared by an attorney, you got your witnesses, it's notarized, it's signaled or initialed on every page, right? That's just further validation that no, this person meant business. This is what we're going to go by. Okay. And again, it's private. It does not have to go to probate courts. So you save all that time, that hassle, the publicity of it all. It can be more costly on the front end to have an attorney prepared and all that. But believe me when I say you save so much more time and energy and money too on the back end with a big, long, drawn out court battle in probate court. Okay. And again, it's for the same purpose, to pass down the property, to extend the legacy, right? And a trust is very unique because it is effective in life and in death. Okay, whereas the powers of attorney are only effective in life, and the will, what we're going to talk about next, is only effective after death. Excuse me, the trust you set up while you're alive, you can benefit from it while you're alive too. But then when you pass away, you have beneficiaries named afterwards. So it still continues in life and death. I think that's pretty cool. All right, so then we're going to talk about the wills. Now, a will is not effective against probate court. It has to go to probate, but it is very important, especially if you're caring for minor children or if you are the guardian of, let's say, a disabled adult. Okay, or if you're the guardian of an elderly parent, something along those lines. Because only a will can name a guardian appointment. Okay, for minors, and for those you have guardianship over. Okay, I've seen it in a couple of cases where not elderly, but over 65 age individual had a will prepared, and although the individual did not have minor children, their own children who were adults, at least one of them, I believe, this person had guardianship over. Okay, so it would have been it's very important to have a will so you can name who you want to be a replacement as guardian. All right. This is very important, especially for single mothers, okay, who have sole custody specifically, because you can name who you want to take care of your child when you're no longer able to. That's very, very, very important. Okay. Even if you are remarried or married and it's not the father of the child, doesn't matter, because unless a step parent officially adopts that child, they're not going to inherit. Okay, so let's say you have a minor child, you pass away, you were married, but that's not the child's father. Legally, don't matter. Okay, legally, I mean the stepfather can go and go to court and petition for guardianship, but it's not automatic. And I've seen stepchildren be taken out of agreements, okay, for inheritances because they were not the biological child. That's here in the state of Michigan. Again, it can be the same or different in other states. You just want to check with an attorney around your area. But step children do not naturally inherit from step parents, but they can, or from step parents, but they can with official adoption. Okay, so don't knock a will. I know there's a lot of kind of downplay about a will because it has to go to probate court, which is true. But again, there's a reason for everything. Okay. And if you don't want to go through the hassle of a trust or anything, at minimum, have yourself a will, get it officially prepared, notarized, witnessed, all that stuff, so that it's harder to challenge in court. Okay. So those are the three plans to prepare before retiring: the powers of attorney, medical and financial, property provisions, especially for real property, personal, digital, intellectual, and then the estate plan, trust, will, and everything else we talked about is all a part of it. And the last little tip I will say is to review, review, review. Okay, at least annually. Again, life happens, things do not stay the same forever. We know that. Review at least annually. All right, that's number one. Number two, review anytime a major life event happens. This can be death, divorce, marriage, birth, anytime something, moving out of state. That's the big one. We don't think about that a lot, but wherever you pass away, that is the county that will have, or wherever you last resided at the time of death, that is the county that's going to have jurisdiction over your estate. Okay, so you want to make sure that you have all of your affairs in order. If you like moved out of state, you have things over here, over there, get it together. Okay. And then last life event, as you accumulate more, okay, you accumulate more properties, your income increases, you have business acquisitions and investments, job opportunities increase, all of that stuff. Always just think about, okay, I have this now. What does it mean? How do I want to extend it? Okay. These are very important, but the most important is that you just review it. Don't do it one and done. There is no one and done in life. You don't learn how to drive a car and then you never drive again. You don't learn how to ride a bike and then you never ride a bike again. Maybe you do, but then as soon as you get back on it, you know how to do it. Okay. So review, review, review. All right. I hope you've enjoyed. If you have, please do like, share, comment, subscribe. Let us know if this was helpful to you. And if it was, again, let us know, give us some feedback. We will be doing deep dives on a lot of this stuff. I think this is September now, so definitely heading into Q4, we'll be going into a lot of these kind of issues regarding, kind of retirement age. I don't want to say end of life, but things that we don't like to talk about. Let's put it that way. Okay. All right. Until then, we will see you again next Thursday, September 26th, same time, 1:30 p.m. Eastern Standard Time. All right. Take care.